Every time you buy a gun from a licensed dealer, you fill out a form the ATF has used for decades to run your background check. And right now, that entire form, along with the rules governing how long your information gets kept and how firearms can be shipped directly to you, is being rewritten. On May 8, 2026, the ATF published a series of proposed rules touching Form 4473, the firearms transaction record every commercial buyer completes, along with separate proposals addressing electronic record keeping, record retention periods, and how non-over-the-counter transactions, including direct shipments, actually work. This entire package has generated a wave of online speculation, some of it claiming the ATF is quietly ending the gun registry once and for all, other claims suggesting the opposite, that digitizing and modernizing these records is really a stealth move toward exactly the kind of centralized database federal law is supposed to prohibit. Neither version tells you what's actually in the regulatory text. I'm going to walk you through exactly what each of these proposals actually changes, address the recurring claim that any of this creates or ends a national gun registry, and explain what's already final versus what's still sitting in a public comment period. Before we get into it, if you want the actual regulatory text explained clearly instead of a confusing mix of acronyms and rule numbers, subscribe and turn on notifications right now. This is exactly the kind of story where the details genuinely matter, and most coverage either oversimplifies it into a registry conspiracy or buries it in bureaucratic jargon nobody can actually follow, leaving you with either fear or confusion instead of an actual understanding of what changed. Let's get into exactly what's changing. Here is the most important legal fact to understand before anything else, because it directly addresses the registry question that's driving a huge amount of confusion around this entire story. Federal law, specifically a provision within the Firearm Owners Protection Act, already prohibits the ATF from establishing any system that consolidates firearms transaction records into a searchable national registry of gun owners. That prohibition isn't new, it isn't part of this proposed rule package, and it isn't something any of these current proposals could override, even if the agency wanted to, since it's a statutory restriction written by Congress, not merely an internal agency policy the ATF could quietly reverse through rulemaking. Understanding this baseline is essential because it means the actual controversy here isn't about whether a searchable national registry legally exists. It doesn't. It's about something narrower and more technical, exactly how individual dealer records get retained, stored, and potentially digitized over time. The first segment is what's actually being proposed for Form 4473 itself, the document every buyer fills out at a licensed dealer. The proposed rule, identified as Document 2026-09182 in the Federal Register, proposes streamlining identity and residence verification requirements, meaning simplifying exactly which documents count as acceptable proof of who you are and where you live. It proposes doubling the performance timeframe for completing a transaction following a NICS background check, giving both buyers and dealers more breathing room before a completed background check expires and the process has to restart. It proposes permitting electronic forms and electronic notice more broadly, along with auto-populating certain fields and allowing attached digital copies of supporting documents rather than requiring everything on paper. It also addresses how private party transfers and what the agency calls firearms handler checks get handled under the broader framework. According to industry compliance analysts who've reviewed the proposal in detail, this isn't a simple wording update. It's a material revision touching the form's overall organization, its buyer eligibility attestation language, and how identification documentation gets handled and retained at the point of sale. The second segment is the records retention proposal, because this is genuinely the piece of the package most directly connected to the registry debate, even though it doesn't actually touch the legal registry prohibition itself. Currently, when a licensed dealer goes out of business, their firearms transaction records, including completed Form 4473s, get transferred to the ATF for indefinite retention, rather than simply being discarded, a practice that's existed for decades, specifically to preserve records dealers would otherwise no longer be maintaining themselves. Records that remain useful for law enforcement tracing a specific firearm back to its original sale in the course of a criminal investigation. Critics have long argued this indefinite retention of out-of-business dealer records functions as a kind of backdoor registry in practice, even without technically violating the statutory prohibition on a centralized, searchable database, because the sheer volume of records the agency now holds and increasingly digitizes for easier storage and retrieval starts to resemble the functional capability a registry would provide, even if it isn't formally organized or searchable the same way. This distinction between a formally prohibited searchable database and a large, growing collection of individual records that could theoretically function similarly if ever organized that way has been at the center of gun rights advocacy concerns for years, well before this specific proposal existed. The new proposal, identified under Regulatory Identifier 1140-AA95, would replace that practice of indefinite retention with defined retention periods instead, reportedly in the range of 20 to 30 years, meaning records would eventually be destroyed rather than held permanently, directly responding to the core concern driving the backdoor registry criticism. Whether 20 to 30 years counts as a meaningful improvement over indefinite retention, or whether it still leaves records accessible for far longer than privacy advocates would prefer, is exactly the kind of question the public comment process exists to surface and debate before any final version gets adopted. The third segment is the electronic record-keeping proposal, a separate but related piece of the package identified as Document 2026-09158. This proposal addresses how licensed dealers maintain their acquisition and disposition records, the internal logs tracking every firearm that enters and leaves their inventory, moving more of that record-keeping towards standardized electronic systems rather than the paper-based processes many dealers still rely on. Supporters frame this as a straightforward modernization effort, reducing paperwork burden and administrative errors for dealers while making legitimate law enforcement tracing requests faster and more accurate when they do occur. Critics raise the same underlying concern that shows up throughout this entire package, that digitizing records that were previously scattered across thousands of individual paper files at individual gun stores makes any future centralization, whether through a change in agency policy or a future administration with different priorities, mechanically easier to accomplish than it would be with millions of individual paper records sitting in file cabinets across the country. The fourth segment is the non-over-the-counter transaction proposal, identified under Regulatory Identifier 1140-AB05, which addresses direct shipment and other transactions that don't involve a buyer physically standing at a dealer's counter. This covers situations like a firearm being shipped directly to a licensed dealer for a customer who initiated the purchase remotely, or other transaction structures where the traditional in-person counter process doesn't apply in the same way. The proposal aims to clarify exactly what verification and paperwork requirements apply in these non-traditional transaction scenarios, an area that's grown more relevant as more firearms commerce has moved toward online research, remote ordering, and shipment to a local dealer for final transfer and background check completion, rather than every transaction starting with an in-person visit to browse a physical inventory. The fifth segment is a detail that got relatively little attention, but reveals something important about how seriously the agency is actually taking the public comment process, rather than simply rubber-stamping predetermined outcomes. A separate related proposal called the EZ Check verification system, which would have let licensed dealers verify another dealer's license status electronically, rather than requiring a certified paper copy, was actually withdrawn by the ATF in July of 2026, specifically because the agency received significant adverse public comments during the standard review period. The agency stated it may reintroduce a revised version addressing those specific concerns in a future rulemaking, but for now, that particular piece of the broader modernization effort simply didn't survive its comment period intact. This detail matters because it demonstrates the public comment process here isn't purely theatrical. Adverse comments can and did result in at least one proposal being pulled back entirely for further work. The sixth segment is the actual timeline you need to track if you want to follow where this goes. The Core Form 4473 proposal's comment period runs through early August 2026, while a related, separate Paperwork Reduction Act notice covering the same form had its own comment window closing in early July. None of these proposals are final law yet. They're proposals, meaning the agency has to review whatever comments it receives, potentially revise the specific language based on that feedback, exactly as happened with the EZ Check withdrawal, and then issue a final rule before any of it becomes binding on dealers or buyers. Let's step back and name the single thread running through this entire package. This isn't a story about the ATF secretly building or dismantling a national gun registry, because the legal prohibition on that kind of centralized database already exists independently of anything in this proposal, untouched by any of these specific changes. It's a story about the much more technical, much less dramatic question of exactly how individual transaction records get verified, stored, retained, and eventually destroyed, changes that genuinely matter for privacy, for dealer compliance burden, and for how efficiently law enforcement can trace a specific firearm when a legitimate investigation requires it, without amounting to the kind of sweeping registry claim that tends to dominate the loudest headlines about this story. It's worth appreciating why this specific package generates such intense speculation in both directions, because it touches a genuine, decades-old fault line in how gun owners and gun control advocates each interpret the same underlying facts. To someone deeply skeptical of federal firearms record-keeping generally, any move toward electronic records and standardized digital retention feels like exactly the kind of infrastructure a future, less restrained administration could eventually repurpose into something closer to a real registry, regardless of today's statutory prohibition, since regulations and administrative priorities can shift in ways a rigid paper-based system simply couldn't accommodate as easily. To someone focused primarily on effective law enforcement tracing and public safety, the same digitization looks like an overdue modernization of a system that's been needlessly inefficient and error-prone for decades, with the defined retention periods representing a genuine, meaningful privacy improvement over the previous indefinite retention practice. Both perspectives are grounded in real, legitimate concerns about the same underlying technical changes, and the actual regulatory text, read carefully, supports elements of both readings without fully vindicating either the celebratory or the alarmist version circulating online. If there's one thing worth taking from this breakdown, it's that the actual regulatory text here is considerably more nuanced and considerably less dramatic than either the No More Registry celebration or the secret registry conspiracy framing suggests. Understanding the real distinction, a statutory registry prohibition that remains fully intact, alongside a genuine, more technical debate about record retention periods and digitization, is what separates an accurate picture of the story from whichever oversimplified version happened to reach your feed first. If this helped you understand what's genuinely changing versus what's still just a proposal, share it with someone who's seen the confusing, oversimplified version. Subscribe so you catch the final rule the moment these comment periods actually close, and I will see you in the next one.